Good day. We're back again with environmental law, and today we are more specifically going to look at the relationship between international environmental law and national law. On the previous chapters, we were talking about international environmental law, we're talking about the conceptual framework of environmental law. Now we're going to look at why we're looking at international environmental law, and how it relates back to us, the connection therein. Well, the connection is based on the principles that are derived from international environmental law that are now also valid in our national law. We're going to look in detail over those principles. This slide does not exhaust all the principles because there are a lot, but it will try to give detail to some of them, and you will fill in the gaps. Now, the principles include but are not limited to sustainable development, precautionary principle, environmental justice, preventative principle, the polluter pays principle, the principle of common but differentiated responsibility. I didn't include some other principles, like the principle of intergenerational equity, principle of is it intragenerational equity. So there are some people that are there, but I could not delve in all of them because it will be a very long lecture and video as well. So you have to look into those as well on your own in your textbooks, prescribed textbooks. Now, the relationship that we are going to talk about in these slides, we're just looking at the incorporation of international law principles into domestic law. That's all you have to know. How is international law? Where did it come from, and how is it domesticated in our law? Where do we see it now in our domestic law? Now, the first principle we're going to look at is sustainable development. And I'm sure by now you are almost tired of this principle because I've been saying it time and time again. But like Sense says, there are a lot of principles within the sustainable development principles, like the principle of intergenerational equity and other principles that are there that are incorporated in our law that we are going to look at when we're now analyzing the right to safe environment under the section 73 of the Constitution, as well as the right as incorporated in section 4 of EMA. So this principle is very foundational. It is evolution of many other principles, and it circles many other principles, and we're going to look into that. Now, the principle in terms of international environmental law, where does it come from? We see the principle in the Hungarian Slovakian ICJ case, wherein the judgment stated that sustainable development is one of the central pivotal considerations that states should take into account when formulating policies which have a bearing on the environment. And then this principle, we see it in the Stockholm Declaration. It links social and economic development. We see it in Article 8, states that economic and social development are essential for ensuring a favorable living and working environment for men and for creating conditions on earth that is necessary for the improvement of the quality of life. So you see it also in the other international environmental laws like the Rio Declaration. We see it being mentioned in the Pulp News case. This is where we get it in international environmental law. Now, in terms of the principle in local legislation, we see it in Section 73, subsection 1b3. We see it in EMA, Section 4, subsection 2e, when it says that development must be socially, environmentally, and economically sustainable. We see it in EMA again when it says that secure and economically sustainable management and use of natural resources while promoting justifiable economic and social development. We also see it in the Water Act. So having seen the backdrop of this principle, you're now familiar with its historical background, and we're now looking at its presence now um, in our national law. You see, in Section 73 of the Constitution, it says that every person has the right to an environment that is not harmful to their health and well-being, and to have the environment protected for the benefit of the present and future generation. We see those traces of the principle of intergenerational equity. We're saying that this generation's actions should not detrimentally affect the action, is it the future of another generation to come, right? And in doing so, we have to secure ecologically sustainable development and to use the natural resources while promoting economic and social development. So this principle is saying that our development is for the betterment of humanity, right? And to ensure the continued betterment of humanity, we must also take into account future generations. Our actions should be able to ensure that the future generation does not is not negatively affected. As we continue on, this principle is also looked into in the case of BP Southern Africa versus MEC for agriculture. In this case, BP unsuccessfully sought an order to set aside a decision made by the MEC for the company not to erect a fuel station. The reason laid out by the MEC was that its guidelines do not allow the erection of a fuel station 3 kilometers away from another filling station in an urban or residential area. Read the full case. This it lays out other different principles as well. And during that case, it says that sustainable development requires the integration of social, economic, and environmental factors in the planning, implementation, and evaluation of decision to ensure that development serves the present and future generation. So in this case, we are looking at someone who wanted to erect a fuel station, and the guidelines were saying that you cannot do that when another fuel station exists within 3 kilometers of that development. So it was going to affect the people around as well as the environment. And the people being part of the environment were going to be affected if two fuel stations were to be erected, because we know the different gases and whatnot that come with erecting fuel stations. And they're saying that sustainable development demands the principles from international law and national law demands that when we are developing, we have to consider our present and future generation. So as a result, we're not going to allow this development to happen. That's what this case is saying. As we continue on, so the principle, I'm sure you read out the lot of different articles that talk about the principle of sustainable development. It acknowledges that development is in any case a necessity, but it should be responsible. It should be a development that is responsible. Responsible development which considers all the relevant factors, right? Now, this also is referred to in the Fuel Retailers Association of Southern Africa versus Director General. There, in this case, you look at the facts of the case and decision on your own. But during this court case, the judge said that pure economic principles will no longer determine in an unbridled fashion whether a development is acceptable. Development which may be regarded as economically and financially sound will in future be balanced by its environmental impact, taking coherent cognizance the principles of intergenerational equity and sustainable use of resources in order to arrive at an integrated management of the environment, among other things. But what this case is just saying is that we have these environmental principles that are there internationally as well as nationally. And these principles should be incorporated in this type of development. And we should not blind ourselves of that. Any development should consider all these principles. And hopefully you as a student of environmental law, having had a historical study internationally as well as nationally and have a sound understanding of this principle will also be able to apply these principles in any development or any questionable development that will be involved with. Now, environmental justice. What is environmental justice? Let's look on it. Environmental justice says that environmental bounty should be equally distributed and certain sectors of society should not bear in an equal brunt of negative environmental impact. So this principle is saying that equality should extend also to environmental harm. I was giving an example in class and I was saying that reasons why people prefer certain suburban areas as opposed to other high density areas because of the presence of high pollution in those high density areas. It is the inequality of environmental harm. There is environmental injustice here in Zimbabwe. Despite the presence of this principle and how it is ingrained in our legal policy, but it is not being enforced or implemented as effectively as it should. So this principle is just saying environmental burdens should be equally distributed all around. We should not have certain privileged sections which know not environmental pollution, but it should all be equally distributed. Even better yet, it should all not be there, be it suburban, be it highly highly populated residential areas of any place. There shouldn't be environmental harm or environmental pollution in the first place. Now, this principle emerged and it is recognized on an international level, or now we want to see it on a national level. These are some pictures of how certain areas are just ripe with pollution while others are not. Now, this principle is seen through the presence of Section 56 of the Constitution. It says that the state must take reasonable legislative and other measures to promote the achievement of equality and to protect or advance people or classes of people who have been disadvantaged by unfair discrimination. So this right to equality also extends to equality in environmental harm. The achievement of environmental justice is a response to the right to equality for all. There's always been unfair discrimination in environmental problems or environmental harm. Black people were the ones who were thrust upon with the environmental pollution, with the landfills in their residential areas. But even now, it's still there despite our so-called democracy. Right? And then we have Section 4, subsection 2C of the EMA Act says that the participation of all interested and affected parties in environmental governance must be promoted and all people must be given an opportunity to develop the understanding, skill, capacity necessary for achievement of equitable and effective participation in natural resource government, etc. So this section is just saying that environmental justice is not only just about the achievement of equally distributed environmental harm, but justice also extends that environmental awareness should be for all people as well, and all people must participate in environmentally affecting decisions or developments, right? So this section also supports that, and the implementation of this principle requires a lot of different parties. We have the need for service delivery. It is much needed service delivery that is going to account for environmental justice. Now, environmental justice and environmental rights. As you can see from the previous provisions that we're talking about, the right to equality, the right to health, the right to education, right to shelter. All these are incorporated in somehow are interconnected with the need for environmental justice. Rights provided under international, regional, and national law, and the rights that we know that are incorporated in our constitution, the right to food, water, right to, they're all connected with environmental justice and environmental rights. For us to achieve the right to a safe, clean, and healthy environment, we must have the right to food and clean water. We must have the right to education on environmental rights, the right to shelter. All these will ensure that environmental rights are achieved. There's an interconnectedness that is there. Now, there are a lot of cases that deal with environmental justice. I'll just speak on one of those cases. So we have the Dora Community versus Mutare City Council case. In this case, Zella, which is a non-government organization, Zella approached the courts for an interdict to stop the Mutare City Council from depositing partially treated waste into the river after the councillors admitted to the pollution and agreed to remedy the damage done. Zella obtained a judgment by consent. However, the Minister of Local Government dissolved the council and replaced it with a commission that refused to acknowledge the council's admission, and thus rendering the court's decision ineffective. So we see that we have a non-governmental organization that came in and wanted to implement the provisions that we were talking about today, the need for environmental justice, so that there won't be any waste that is put into the river. But we see that it is a different branch of government now comes in and dissolves the council and ensures that there is no implementation or enforcement of that decision. Environmental rights are very, very important, just like any other right. But we see the deprivation of that right on the arbitrary decisions made by these ministers of local government in this case. And then we have the Melvin Mudiwa case versus Mbada Mining. Here we see an agent application filed in 2009 by Chiadzo community members with the assistance of Zella again, seeking protection against arbitrary evictions, which had many mixed outcomes. The community sought to prevent their displacement and resettlement until the issue of their compensation had been finalized, and the environmental impact assessment of where they were going to be resettled had been done. However, the court dismissed the case, citing that it was not an urgent matter. The judge pointed out that the community should have raised the issue when mining activities commenced in 2007. The court held that the applicants had no legal standing to bring the case on behalf of the community. The judge further said that the respondent had not refused to pay compensation, although no agreement had been reached in the event of a deadlock. 6 months later, the villagers were relocated to another village without compensation, except $1,000 each family, as what the government and mining company called a disturbance allowance and groceries for 1 month. You see the injustice there. All these resettlements on account of mining. It is quite saddening that such situations are happening despite the presence of these environmental provisions that we are talking about. So these are just some of the cases highlighting what is there on the ground. Now, climate justice. Climate justice is a faction of environmental justice. It focuses on the equal distribution of the burdens of climate change and the efforts to mitigate them. Right? Climate justice is fundamentally about paying attention to how the climate change impacts people differently, unevenly, and disproportionately, as well as redressing the resultant injustice in fair and equitable ways. A climate justice approach focuses on who benefits, who loses out, and in what ways, where, and how situation. So climate change, we might talk about the whole climate justice and climate change, and we tried to establish this in class, and it is very it would be very ignorant on my part to assume that everyone knows what climate change is. So climate change is caused, at least in part, by anthropogenic sources of various greenhouse gases, especially carbon dioxide, which comes from the burning of fossil fuels. It is the economically developed countries now. So this is what climate change. These greenhouse gases that go into our atmosphere and tear up the ozone layer, causing different climatic changes thereabout. So in terms of climate justice, we're saying it is the economically developed countries of the so-called global north that have generated the most greenhouse gases since the advent of the industrial revolution, and they have thereby benefiting from the use of global atmosphere as a sink for the harmful um, byproducts of their economic development. So most of the climate change that is happening today is because of what has been done by developing countries over the years. So climate justice is now saying that there has to be equal distribution all around, because um, it is not, there are some countries who do not really even take part in the cause now, or the effects that is happening here. Now climate change is caused, at least in part, by, we talked about what it is. Now why is this concept there, the concept of climate justice? You see these tables, we see that right there we have megatons of carbon dioxide per year. We have China, which is emitting really almost dramatic and exaggerated amounts of greenhouse gases into the atmosphere. And Africa, as you can see from the table there, it's only emitting 2.5% of it. And then we have the United States, 20%, China 21%, Russia 5%. But you see, just the whole of Africa alone is emitting, you're saying that 3.7%. So we see the disparities there. And this is why climate justice now comes in, because the disparities in responsibility for climate change. And now, according to Newell et al., there are four pillars of climate justice. We have procedural climate justice. It is fundamentally about the process for making decisions about the impact and responses to climate change that are fair, accountable, and transparent. And then we have intergenerational justice, and then we have distributive justice, and then we have procedural climate justice, which is a process by making we talked about this process. And then, so this climate justice approach stems from the common but differentiated responsibility principle. It has been there, it is well documented how communities that have distributed the least to climate change are the ones who are mostly unduly burdened and harmed by it over the decades. Proponents of historical responsibility argue that those with more responsibility for causing global climate change should have a greater role in preventing or mitigating its impact. Approaches based on this idea adopt a basic polluter pays principle. This term, climate justice, was coined in 1989 by Schlossberg and Collins, and its precursors go back much further, because we have intergenerational justice that was there, justice to future generations, which also now gave way to climate justice. And when we're talking about the 4 pillars of climate justice, we refer to distributive justice. It deals with how cost and benefits of social goods and ills are allocated, especially and temporarily across the society, and identifying the goods and identify the entities with whom they are to be distributed, and identifying most appropriate modes of distribution as well as what is based on. So those are the pillars of climate justice. For us to achieve climate justice, we have to do procedural climate justice, distributive climate justice. We have to look at intergenerational justice and so forth. Now, the precautionary principle. Where do we get this from? We see this principle in Article 3.3 of the Convention on Biological Diversity, Bamako Convention, wherein they banned the importation into Africa and control interboundary and transboundary movement and management of hazardous wastes. But this principle, it is evident in international environmental law. We talked about this. You look it up from your previous chapter, where specifically it is in international law. This way, it says that where there are threats of danger to the environment, serious or irreversible danger, or there is a lack of scientific certainty, then development of proposed project should be postponed pending the resolution of this principle. So there should be precautionary measures that are taken to ensure that there is no environmental harm when a development is about to take place. There should be cautions that have to be made on, and that development has to be postponed until measures have been taken to ensure environmental protection. Now, this principle is evident now in our national law. In Section 4, subsection 2D of EMA says that environmental education, environmental awareness, and the sharing of knowledge and experience must be promoted in order to increase the capacity of community to address environmental issues, gender, values, and so forth. So in this section, we are seeing that there's a need for environmental awareness for there to now eventually be the precautionary principle. You cannot take caution if you are not aware of the environmental rights. Right. A product of the precautionary principles are the environmental impact assessments, which, according to EMA, an evaluation of a project to determine its impact on the environment and human health, and to set out the required environmental monitoring and management process. So EMA, if I'm not wrong, it should be section 97 of EMA. It gives out, it says that schedule 1 project, first schedule project, like the erection of industries, dams, and so forth, should have environmental impact assessments be done before those projects are done. This mechanism, environmental impact assessments, is a product of the precautionary principle, because we are saying that before a project is done, we have to look into the potential environmental harm that would happen as a result of the project and try to ensure that measures are taken to ensure environmental harm. Then we have the preventative principle. We know where that comes from in international law. This principle is just saying that activities which will cause harm is to be avoided at all costs, thus minimizing environmental damage. This, according to myself, is one of the most it is on the first line of the tile of all the principles in environmental protection. This principle, unlike the others, which say we must minimize harm, we must remedy the situation, this principle is saying we should not even incur any environmental harm in the first place. We should avoid environmental harm at all costs. Not only that, we should take action to minimize environmental damage at an early stage and, if possible, before the harm even occurs. That's what the principle is saying. It is evident in our law, there are provisions within EMA and also even in the Constitution, which talks about the preventative principle to avoid environmental damage. We will look specifically to those provisions when we are now dealing with strictly EMA legislation in lesson 6. Now, the polluter pays principle, we see this principle in Principle 16 of the Rio Declaration, and we see it evident in section 4 subsection 2g. Says that any person who causes pollution or environmental degradation shall meet the cost of remedying that such pollution and any resultant adverse health effects, as well as the cost of preventing, controlling, minimizing further pollution. So this principle is just saying that we should make the person who caused environmental harm to pay for the remedy of such environmental harm. This principle, we see it in our law in pollution permits, wherein there are affluent and solid waste disposal permits regulations. We are going to look in detail when we are now dealing with the regulation and implementation of environmental protection. It should be lesson 7 or 6, wherein people pay when they are given pollution permits. We will look into those. And then the cases that deal with the polluter pays principle, we'll read on these cases. The Dora community case, we talked about this, and then we have the Bambanjeni case, we have the Chitungwiza municipality versus Majande and others. Look into those. They're just giving light to the polluter pays principles. So the principle is just saying that those that are able to pay for any environmental damage should do so to remedy that environmental damage. And unfortunately, this principle is excusing many environmental damages that have been happening, because a lot of companies are throwing money at the problem. We see a billion-dollar company which does environmental harm, knowing that even we have more money, we'll gain more profits, despite the environmental damage that will happen if we are to get $1 billion in profit, and that $1 billion is at a cost of 10,000 worth of environmental harm. Then we ought to get that $1 billion and just pay up for the environmental damage. And even in worse cases, they even ignore the environmental damage and do not even pay at all. So those are the problems that we're facing today. Then we have the common but differentiated responsibility principle. We know where this principle came from. We talked about it. Principle 23 of the Stockholm Declaration says that states that it is essential to consider the extent of the applicability of standards which are valid for the most advanced countries, but which may be inappropriate and have unwarranted social costs for developing countries. So we know where this principle came from, and it's saying that environmental responsibility is not equally distributed in all states, and it acknowledges that, and thus the responsibility for Zimbabwe to ensure environmental protection is not as great as it is for the United States and China, given those graphs that we showed on greenhouse gas emissions, on overall pollution. And then this section also looking at the other frameworks that talk about the principle of common but differentiated responsibilities. And that's why you see the goals, our national environmental goals, pollution, we're trying to lower it, but our goal is not as great for other developed countries, and the reason for that being because of this principle. We're showing the graph, principle 7 of the Rio Declaration. I'm just repeating the stuff that we already discussed before. So that's what this principle all about. So in closing, all these principles that we're talking about, they're coming from international environmental law, and they've been incorporated in our national law. Such incorporation, we talked about it, and that is where we see the relationship. That is why we were talking about international environmental law in the first place, and how it relates now to our national law, how it has been domesticated. All these principles, the ones that I talked about and the ones that I did not talk about, that you have to look and research on your own. All these principles have to be evident in our national legislation. They are a part of our law, and they should be incorporated in every development. Anything that relates to environmental harm or has the potential to ensure environmental degradation, then the incorporation of these principles will ensure environmental protection. So yeah, thank you.